so much for joining me today.
Thank you for having me. Pleasure to be here.
So today we're going to talk about a subject that I think most people don't really enjoy talking about, and most people are even scared to ask questions about, and that's both employees that have been let go, as well as, of course, managers and business owners. So I'm really happy to have you here today. I know you've got a wealth of subject matter knowledge and experience on this. So I'm really excited to ask you some questions and get a chance to get your answers so that we can hopefully share the wealth of knowledge with our viewers. So in the meantime, why don't you tell us a little bit about you, what you do, of course, and where you work, and what you enjoy the most about it?
Yeah, absolutely. So thanks for having me. Real pleasure to be here. So I'm an employment lawyer. I do mainly wrongful dismissal type work. Big majority of my practice is devoted to plaintiff side wrongful dismissal litigation. So I represent individuals who have grievances against their employers, particularly with respect to the amount of notice that they're given of their termination. We also work on some other issues that come up in that context, such as some disability stuff, as well as the duty to accommodate and some human rights work.
All fascinating subjects, and I'm sure we can talk a lot about each one of them, right?
Yeah, I was just going to say my favorite aspect of the job is really representing people who, unfortunately, for a number of reasons, aren't in a position to help themselves navigate these sort of difficult situations that they face with their employer. So, I think for a lot of my clients, just having someone in their corner to sort of cheer them along and help them sort of get to the finish line is a great help, and it's something that brings me a lot of pleasure.
For sure. I'm sure it's extremely satisfactory when you get to get the kind of compensation that individual deserves, right? And I know dismissals and constructive dismissals, there's so much sort of gray area, but it really defaults to a few things like the ESA, like the common law, and then of course the contract itself, right? So you're the expert here. Let me ask you a question. I'm really curious to hear what is the official difference between a wrongful dismissal and a constructive dismissal?
Yeah, so look, the short answer to that question is that a constructive dismissal falls under the umbrella category of wrongful dismissals. So really, a constructive dismissal is one specific type of wrongful dismissal that can take place. With respect to constructive dismissals in particular, the distinguishing feature that we're looking for is that the employee is actually the one who raises the issue and takes the position that they've been constructively dismissed. So in other forms of dismissal, it's usually the employer who sort of takes the effective action to say, you've been terminated. But the difference there is that in a constructive dismissal, the employee actually has to take that step. So in order to assert a claim for a constructive dismissal, the employee would need to identify something that the employer has done and that would rise to that definition. So there's a certain class of behaviors that an employer is not entitled to participate in. And when an employer does those things, they're sort of running the risk of having a constructive dismissal found.
Right. And I know I remember listening to somebody else speak about constructive dismissals, and there's very specific criteria. There's sort of a formula to all of it. And, you probably know this a lot better than I do, but I remember the employer's office had to be moved a certain distance away so that it's no longer feasible for the person to commute, or there had to be a salary reduction to a certain percentage. And that's what actually qualifies it as constructive. Can you walk us through some of these factors just so everybody knows what they are?
Certainly. So look, it's not closed, but there are certain factors that our will consider, if an employer is engaging in certain kinds of actions, it can trigger a constructive dismissal and give the employee the ability to sort of assert that claim. So some of the things that an employer can do typically revolve around changing a fundamental aspect of the employment relationship. So examples include, reducing an employee's salary by more than 20%, reducing an employee's hours by more than 20%, changing the location of employees' place of work in a way that adds more than half an hour to their commute, demoting an employee, so taking away their title, even if you keep their salary the same, and largely their duties, taking someone's title away can trigger constructive dismissal. And of course, taking away somebody's leadership function. So if somebody taken from, say, a director level down to a management level, or from a management level to an individual contributor role, that can also sort of trigger a constructive dismissal. And then, some examples that people don't often think of as often when it comes to constructive dismissal, and frankly, maybe a little bit more tricky to prove when it comes to litigation, include subjecting an employee to harassment. So if if an employer is harassing an employee, that employee may be able to make a constructive dismissal claim. And then sort of part and parcel with that is failing to meet the duty to accommodate an employee's human rights.
Very interesting.
So if an employer engages in any of these things, they may be running the risk of being found to have constructively dismissed the employee. If an employee has any of these things happen to them, they should probably consult with an employment lawyer to see if they might have access to this kind of a claim.
I know one of my clients recently the employee actually asked to be demoted. They no longer wanted the senior management role. They wanted to have a little bit more of a work-life balance. They were perfectly fine with having a reduction in salary that reflected their new status. What would be some of the steps that an employer needs to take in order to protect themselves from any sort of future, dismissal claims, constructive dismissal claims, and make sure that everybody's on the same page? But obviously, a lot of my clients, they are employers. So we want to make sure from an HR standpoint, from a contractual standpoint, that we are protecting them, during the course of the relationship, as well as after the course of any sort of employment that they might offer to somebody. So what would be the steps that they can take in order to make sure that they're protected?
Yeah, so that's a really unique circumstance that you drive in. And really sort of the key feature that distinguishes that one from a viable case for constructive dismissal is that the employee is the one who requested it. So if a constructive dismissal is to be found, the action truly has to be unilateral, meaning it only came from one side, and that one side has to be the employer side, right? So if you consult with an employee, you get their consent, you speak to them about this decision, it's a decision that both parties have reached mutually, there's much lower chance of that person then bringing a constructive dismissal claim and arguing that this was a unilateral change if it's something that they participated in and negotiated with the employer. So that's what I would say, with respect to your clients. First of all, they should be calling me if they needed a little bit of help with navigating that kind of a scenario. But one of the key tips that I would give them is that, in order to avoid any constructive dismissal claims, you should probably, work with that employee to have their consent and make sure that they're informed. The other sort of strategy to avoid it is to provide extreme sort of advance notice of that change coming. That notice would be commensurate with what, the amount of notice that person would receive if they were to be terminated, for example. If you provide them with the equivalent sort of common law notice of, a change of location of work, for example, then the employer has actually met their duty to, inform that person well in advance of that change happening.
Very interesting. Thank you for that. And yes, I'm always a big advocate for getting everything down in writing from both sides, making sure that everything is witnessed and signed, and we keep everything on file, right? That's one of my biggest sticking points. You mentioned something interesting earlier on when you're talking about sort of some of the things that you really enjoy doing in your role, and making sure that individuals have the information that they need in order to understand their rights. So one of the things that I think is very, very fuzzy for a lot of both employees and employers is the duty to accommodate. And so I find with smaller businesses, small to medium-sized businesses, a lot of employers and managers move straight to termination when there's some sort of a pressing circumstance and the employee needs special accommodation. They don't go through the process of, documenting and understanding what that accommodation is and how we kind of work around it to make sure that we do meet the needs of the employees and the employers. Can we talk about this duty to accommodate? What do employees and employers need to know about it? What is it sort of hinged on?
Yeah. So Ontario has human rights legislation that provides protection for employees. So there's certain specific grounds that are protected under this law, right? So it's not that all discrimination is banned. In fact, there are some kinds of discrimination that we as a society view as being very good discrimination. For example, I have to have a law degree to do the job that I do. If I don't have a
Right.
law degree and I apply for this job, I'm probably not going to get an interview. And that's the kind of discrimination that we agree as a society is actually helpful.
Right.
What's not helpful, though, is this list of protected grounds that we've decided deserve that protection. So these are some of the things upon which you're not allowed to be discriminated against. So examples include age, ancestry, color, race, citizenship, place of origin, ethnic origin, creed, disability, which is kind of a major one that comes up in my practice quite a bit, family status, marital status, gender identity, if you're receiving public assistance, a record of offenses in the context of employment, sex, including pregnancy and breastfeeding, and sexual orientation. So these are all things where we as a society have decided that an employee who's working can't any sort of action again on the basis of any of these things. Right? So that means that in Ontario, an employer has a duty to provide accommodations to an employee to allow them to continue to work, despite what may be going on in that employee's life, whether that's a disability issue, maybe they're pregnant. These are all the kinds of things that there's a prohibition from an employer making specific decisions about that employee on those bases. Right? So the law holds that the employers have a duty to provide these protections to the point of what's called undue hardship. And what that means is that in order to terminate an employee, for example, if you were to terminate an employee who had just taken sick leave or was on a maternity leave, or if you were to say refuse to allow a religious employee to take breaks for prayer time, these are the kinds of things that can amount to a failure to accommodate the employee's human rights.
Absolutely. And I find that fascinating, the concept of sort of the duty to accommodate until undue hardship and what each business considers that undue hardship, right? So whether their operations are being disrupted, it may mean a change of shifts potentially, right? Or a slight fluctuation. Can you tell us what sort of that definition is, that undue hardship? Where do we, as employers, where are we allowed to sort of say, this is it, this is where I, unfortunately we have to part ways because I can no longer accommodate this?
Yeah, so that's a very good question, and unfortunately, it is an extremely difficult question to answer in this context. It really, the answer comes down to a very sort of specific individual context. But what I can generally say about it is undue hardship is a very, very high bar at law. So there's a couple of factors that a tribunal would consider when they're making a decision about the defense of undue hardship, and those factors are costs, so the costs associated with providing that accommodation, and health and safety requirements. So whether providing that accommodation would pose potential harm or a safety risk to the public. So with respect to costs, as I said earlier, the bar at law is quite high. The employer would have the onus of proving that the accommodation would cause that undue hardship. And in order for there to be a finding of undue hardship, there has to be an objective sort of verifiable cause. So, things like invoices for contractors to come in and build, say, a ramp for somebody in a wheelchair. Like, these costs have to be verifiable. They also have to be explicitly associated with the accommodation, right? So it can't just be, an invoice for a coffee run or something like that. It has to be an invoice that's specifically, connected to the accommodation that the employer is attempting to provide. And these costs must be so high that the employer's business is affected to the point where viability is a question, right? So, I think the sort of wheelchair ramp example is quite good. If somebody has to, invest tens of thousands of dollars and that's going to wipe out all their profit for the year, and they're not going to be able to make any money as a result of that, they may be able to avail themselves of this defense. But of course, even sort of taking the steps to get there, meaning, they'd have to get an estimate, they'd have to sort of be able to provide these invoices. Employers have sort of a significant onus and duty to sort of prove that they are going to hit that threshold of undue hardship if they do, move ahead with the accommodation. So I think an employer who's dealing with this situation, fortunately, have to do sort of the math and the homework and sort of make sure that they get all their invoices in line, that they can reasonably connect those invoices to the accommodation that's being requested by the employee. And if they're truly unable to provide it, then they have the option of trying to prove that to the court. The other sort of major factor here that I mentioned earlier is health and safety concerns. So,
Right.
if providing that accommodation could create a situation that creates significant harm to the public, then that harm to the public is another factor that could be considered in the defense of undue hardship.
Can you give an example, Walter, of what that might look like? Automatically, for me, when it comes to sort of any sort of public safety concerns, I think about TTC drivers that may have drug addictions or something like that, or alcohol addictions, right? So we get into that human rights protected grounds of things, but it is a threat to the public potentially. So can you give us an example of what you're talking about?
I mean, I think that's a perfectly fine example, right? So, even a single instance of intoxication in a safety sensitive position can amount to just cause for termination. Now, of course, if that individual has, an addiction concern, they do need to be provided with accommodation, but I don't think that accommodation would involve them driving a bus for work anymore, right? Like, these are the kinds of things that, an organization like that, I'm not going to name any specific organizations,
Sure, yeah.
organizations that hire bus drivers would have to sort of deal with issues like that. And frankly, I would think that it gets quite complicated, just given the fact that there is, that accommodation angle on top of that health and safety concern. So that's an example. I think another example would be, for example, individuals who are seeking shelter at a public shelter might have certain, disabilities that cause them to behave in erratic or violent ways. That shelter may have the ability to claim that, providing accommodation to that individual, providing them housing, might put others at risk of harm. And
Right.
That's a situation where they would be able to claim undue hardship. I know it's not a very sunny example, but it is, an example that touches on
It's a real one.
that I'm speaking about here with respect to the government's approach to this.
Absolutely. Thank you for that. That's a great example of that. When it comes to most sort of wrongful dismissal claims, you obviously work with the plaintiffs for the most part. Can you tell us who has the onus of responsibility to provide proof of any sort of wrongdoing or non-wrongdoing? Is it a 50-50? Is it primarily on the employer? How does it work?
Yeah. So again, the employee, brings the claim that they're owed accommodation. So, they would probably talk to an HR person or their manager and say, hey, this is what's, I'm not able to do these specific things at work. And I require sort of a modified plan to do that. So then, if the employer is unable to provide that, then the onus actually falls on them to prove that, they're going to hit a level of undue hardship. That's why, they would have to collect those invoices, those estimates, and do that costing to sort of demonstrate to the court or tribunal that, providing that accommodation is going to so substantially alter the business's viability that the business might not even be able to run if they have to do that. So I would say, the short and long answer is that does, fall on the employer to sort of handle in response to the employee's request for that accommodation. Now, of course, if that employee never makes the employer aware that they need these accommodations, then
Right.
the employer is obviously not triggered to provide them. So, to that extent, I think the employee has sort of that initial onus of asking for that accommodation and sort of describing what they need in order to continue to do their job.
Awesome. Thank you for that. I think that's useful information to a lot of people. Last question for you, and I already know the answer to it, but I think a lot of people will find it very interesting. How long does somebody have in order to file a wrongful dismissal claim with a lawyer after they've been terminated?
Yeah, so the law in Ontario, with limitation periods generally, is 2 years from the date of injury. So you would argue that if you do have a wrongful dismissal claim, the date of your termination or the date that you get your termination letter is probably the date at which you might have a claim. So I would say, don't wait 2 years. Just try to get in contact with somebody as soon as you can if you do have a claim. But 2 years is sort of that point at which you're going to have to really justify why you didn't start it sooner.
Fascinating. Well, thank you so much for your time. I really appreciate it. I'm sure that our viewers will find this very insightful. And I'm hoping that we can work together on another episode sometime soon.
Awesome. Can't wait. Thank you.
Thanks so much. Bye, Walter.